For today's online talk, we will start shortly at 3 p.m. For those who are here early, thank you for waiting patiently. While waiting, we would like to share with you a short video from the firm.
I founded the firm in September 1985 with the vision of seeking truth and justice for our clients and not just winning their cases. Over the years, the team has achieved many significant milestones. We are today recognized by the Legal 500, Asia Law Profiles, and Asian Legal Business as a recommended firm in various practice areas. While we have embraced technology to make our services efficient and responsive, we continue to grow on the bedrock of meticulous preparation and hard work, for which there is really no substitute. As legal practice becomes increasingly international, we keep ourselves ahead of the curve with our relationships with lawyers from around the world. Our firm is a founding member of the League of Lawyers, a growing international network of law firms in 20 Asian and European countries.
We believe in partnering with our clients to protect and grow their business. We achieve this by holding firm to our values of integrity and justice, while giving our best to deliver effective and efficient solutions. Instead of just legal services, we focus on developing great working relationships based on understanding and respect.
The firm invests in its team and emphasizes professional development. We are keen to share our knowledge and publish our articles on our website. And we also give back with our corporate social responsibility activities. We cultivate a passion for the law and enjoy what we do. This brings out the best in us for our clients today and tomorrow.
We regularly advise foreign clients, including many Chinese investors, and have a ready appreciation for different ways of doing business. In corporate matters, we offer relevant and commercial solutions, often raising issues that clients may or may not have realized before. In negotiations, we believe in facilitating win-win outcomes.
Hi, good afternoon, everyone. Thank you for joining us for today's online talk entitled Property Transactions Requiring State Consent. My name is Diana. I'm a Senior Associate with Ma Wing Wai & Associates, and I will be your moderator for today's session. Before we start today's talk, let me introduce the firm and what we do. Ma Wing Wai & Associates is a mid-sized law firm that was founded in 1985 by Datuk Ma Wing Wai. Our able team today comprises 22 lawyers and a support team of 19. Datuk Ma is today a consultant with the firm, following his retirement from the Court of Appeal bench in 2015. The firm continues its tradition today of working primarily with SMEs, family businesses, and individuals. We are a full-service law firm with a corporate department, a dispute resolution department, including litigation, adjudication, and arbitration, an employment and industrial relations department, and a department focused on servicing the needs of individuals and families. Our practice groups indicate some of our focus areas, which are supported by talents from both our corporate and dispute resolution teams. Today's talk is part of our Ma Wing Wai and Associates online talk series. By way of background, we have been organizing monthly lunch talks at our office since 2013, some of which were also broadcasted live. But with the COVID-19 movement control order, we have moved online in order to continue with our objective of sharing knowledge, raising awareness, and encouraging networking for clients, potential clients, and in-house counsel. Today is our second talk in our online talk series in 2022. Before I continue, please be reminded that this talk does not constitute legal advice. In the event you require specific legal advice to your matter, please contact us for a complimentary legal consultation. Details will be given at the end of this talk. Now allow me to introduce today's speaker, Sarah Kambali. So Sarah is our partner in our conveyancing and Sharia estate planning and wills, trust and probate department. She advises on documentation for real estate, loan facility, and inheritance of a Muslim, namely on faraid, wasiat, and hibah. Sarah's areas of practice include banking and finance, commercial contracts, conveyancing, esports, media and entertainment, sports services contracts, Sharia advisory wills, trust and probate. If you have any questions, please don't forget to post it out on the Q&A chat box below, and our speaker will address those questions at the end of the presentation. Over to you, Sarah.
Thank you, Diana, for that lovely, very lovely introduction. Good afternoon and good evening to everybody who's attending this talk today. I am Sarah Kambali. This year would make me, I think, 14 years in practice. And I've been doing more conveyancing rather than Sharia. But my passion for Sharia is as the same, because I would like to help people who has problems or issues or wanting to know how to distribute their estate after they have demise, because there's not enough information out there for Sharia as well. But right now, I am now going to share with you what are the top points. Today, our top points for today's talk is 1, to understand the restriction in interest. What is this? 2 is to define and what is the effect of a consent. 3, you need to know what are the types of consent that is applicable for each and every property, if there is any. And 4, our 4th top point is to understand simply what is the process and possible timeline of a consent application. Let's move on to the first top point, shall we? Whenever you see a title, you would see this line at the bottom, or at least at the second page on the top. It will say either sekatan kepentingan or sekatan kepentingan. So what is sekatan kepentingan? It's a Malay, translated to English is restriction in interest. Allow me to speak in bahasa. It says that tanah ini tidak boleh dipindah milik, dipajak, dicagar, dan digadai, melainkan dengan kebenaran jawatan kuasa kerja tanah wilayah persekutuan Kuala Lumpur. Okay, this obviously is a KL property. All right. So in this KL property, translating it in English, it says this land cannot be transferred, mortgage, charge, or another word for charge. Gadai and charge is the same. Without the consent, kebenaran is consent of KL Land Office. So the second one, this sekatan kepentingan is the same, but the only person that's mentioned here is not KL, is dengan kebenaran pihak berkuasa negeri. That means with the consent of the state government. Okay, so this is what restriction in interest means. It means you cannot transfer any kind of dealings. You either transfer by way of love and affection, or you transfer through sale and purchase agreement. You can't do that until and unless you have received a consent from the relevant land office. How do we understand this? So I have explained restriction in interest is sekatan kepentingan. So you have to look at the land title itself. Don't be fooled when people say, oh, my title is freehold, so no consent to apply. Or my title is leasehold, so that means I have to apply consent. You have to look at this part of the sekatan kepentingan. If it says nil, tiada, means no need to apply. There are some lands, they are freehold, but you have to apply for consent. And there are some land that are leasehold, but you don't need to apply for consent. Why is this? Because you need to look at the Sekatan Kepentingan. It is an imposition by the state authority, the state government, to make sure that you are not dealing with the land as and when you want to please. You know, they want to keep record on certain lands when it is changing hands. So you have to apply for state authority consent. All right. So in order to deal with the land, like I mentioned just now, I'm repeating, you have to apply state authority consent. This consent is the approval from state authority itself. So how do you do that? Every state has different kind of rule setting forms. Yeah. So in order for you to apply for state consent, you must make sure your lawyer understands, or whoever that you appoint understands, to go to the land office or have the forms which is relevant to the land office. State authority consent for Kuala Lumpur may not be the same as Selangor. And as you will know, Selangor has 9 different smaller land office and 1 main in Shah Alam. Kuala Lumpur has only 1. So you apply there only. But in Selangor, you have to apply, you have to look at where the title resides, or where it's located. So if it's Geran, then you go to the Shah Alam. If it's Geran Mukim, then you have to go to the smaller states to apply for state authority consent. What do I mean by smaller states? Means that in Selangor, there's smaller land office. There's 9 actually. I can't remember all 9, but there's Pejabat Tanah Petaling, there's Pejabat Tanah Gombak, there's one in Sepang. So there's different, and there are 9 altogether, plus the 1 headquarter in Shah Alam, which is altogether 10. So Selangor has 10 different land offices. Okay. So what do you do if you find out that your title has a restriction in interest? This is what you do. You have to make sure that your agreement is conditional. If you're selling the property, it is conditional upon getting that consent. Does this mean that that consent can be rejected? Yes, it could be rejected. Some state consents, although they don't mention it's Bumiputra, sometimes if it is owned by Bumiputra and it is now sold to a non-Bumi, then most of the time, I don't want to say sometimes, most of the time it will be rejected first instance. That is the usual. However, even though it's being rejected, doesn't mean it's the end of the road. You can appeal. Of course, this means it takes more time and costs, but this is what needs to be done as you apply for state approval, the consent. So in your agreement, there will always be that part where it says the agreement, the selling of this property is conditional upon getting the state authority consent. So what does it mean by conditional? It means that the 3 months, usually when you sell a property, there's 3 + 1, 3 months to complete the whole transaction. But because there's a state consent, you cannot automatically count the 3 months from the date the SMP is dated. So the SMP might be dated today, for example, but you have a state consent. You can't count from 9 February, 3 months to complete. You can't. You have to count on the day the consent is received. So let's just say you apply for state authority consent and you receive it in, I'm trying to be realistic. So let's say March end or April beginning or middle. So let's say 15 April, for example, you received the state consent. Then your 3 months to complete the transaction will only start then. Yeah, what happens to the February, March, April? It's a conditional time. Okay, it's a conditional time. Now, Now that we've seen what is restriction in interest, we are now going to go to what is the definition and effect of consent. In Section 5 of National Land Code, well, for those who are not familiar, National Land Code is the law that governs all legal and about land matters in Malaysia. So in National Land Code, when we say NLC's National Land Code, Section 5 is a section where it defines restriction interest, what is a transfer, everything is defined in there. It's a very long Section 5, okay? So Section 5, one of the definition is that what is a restriction in interest. So this is what it is in National Land Code. It says any limitation imposed by the state authority on any of the powers conferred on a proprietor, the owner, or on any of his powers to dealings under the Act. Means under the Act, you have dealings of transfer, you have dealings of charge. All these things need state authority consent when you have restriction in interest. Right. Now, dealings under National Land Code comes from Section 205 onwards. So what are dealings? Dealings are like transfer, lease, charge, lien, and easement. Those are the dealings in Section 205 National Land Code. And usually these dealings are registered or endorsed on the title. And also the restriction in interest is also endorsed on the title. But however, there are things that if you look at the title, okay, state authority consent, tiada, nil. So I can buy the property lah, easy. However, you must be aware that there are other kinds of consent that may be imposed even though it's not on the title. So the example is like foreigner consent. If you are a foreigner to purchase a property, you have to apply for consent. There is also low cost consent. Low cost consent doesn't reflect on your title. Low cost consent will be reflective of your sale and purchase agreement, and from there onwards, it will be recorded, but it's not endorsed on the title. And another is the Bumiputra consent. The two things that I know that will be reflected in a title is the state authority consent, the Sekatan Kabupaten, and another one is the Malay Reserve. If it's Malay Reserve, you can only sell to Malay and there's no consent about it. You have to only sell that. So that's the two things that is endorsed on the title that you need to know. Okay. As I said previously, understanding this restriction in interest, it actually limits the rights and powers of the proprietor to deal with the land freely. This means that, yes, the government gets to see who purchased the property. That's one of the most top effect of a consent. Of course, on the buyer or the seller point of view, the top effect of a consent is wasting time and precious money. We understand that. But the actual effect of a consent is to regulate the change of hands of title in the country. Yeah, so that's why most of you will see there is a state authority consent on a title. So now, let's go for types of consent application. In Malaysia, in a general view, there's these 4 consent applications. One is state authority consent, which is endorsed on the title. Foreigner consent, not endorsed on the title, but you can know through National Land Code. It's under Section 433B. That's where you have to apply for foreigner consent. Low cost consent. Okay, low cost means the house is a low cost. Last time low cost was 200K and below. So if you have a low cost house or you're buying a property that's really at that kind of level, it could be a low cost property. Yeah. And third is Bumiputra consent. And this is also sometimes not endorsed on the titles. Excuse me, sorry. All right, anyways, so we have these 4 consents. Yeah, let me take you through it one by one, because I see some of you are already asking questions with regards to this. Again, I'm repeating this because this is state authority consent. You have, when you see it on the title, clearly there's a state authority consent to be applied. Yeah. So this sekatan kepentingan is the restriction which makes it state authority consent to apply. Is it on leasehold property only? As I mentioned, no, not at all. Sometimes freehold properties have consent. I know some Bukit Jalil properties, freehold, but you have to apply for consent. And there are some in Puchong, which is leasehold, but no need to apply consent. So it really doesn't matter whether it's freehold or leasehold property. You have to look at whether there's a sekatan kepentingan, the restriction in interest. So where is it to be applied? Like I mentioned just now, state authority, either the district land office or the top land office, the head of the land office. Whose obligation it is it to apply for this state authority consent? The obligation is upon the person who owns the property. Because you are selling and it's yours, you cannot transfer it to another person. So in this case, if it is a sale and purchase, it will be obligated upon the seller, or in this case, we call it vendor, to apply and also to bore the cost of it. Means that whatever the application is, let's say, I know for a fact Penang is application is 10,000, yeah, 10,000 ringgit for a state authority consent. Wait, no, that was foreigner. I think it's about, I can't remember, 5 or 3, I can't remember. But KL is 50 and Selangor, that's different. Selangor is 30 if I'm not mistaken. Yeah. So this cost may differ from one to another of the land office. So who pays for this? It will always be the seller, the vendor. Or in the case of transfer between, there's no monetary, maybe you're transferring it to your sister or your friend or your mother or your father. So who owns the title? Who owns the property? That person have to apply for the consent and pay for the cost of it. Consent to charge, this is different. Consent to charge is the obligation of the purchaser, because the purchaser is the one trying to get the loan to be approved. It's not the vendor, it's not the seller. The seller is not getting any loan out of it. They're getting the money, yes, but the application to register the charge is on the purchaser. So that means the obligation is on the purchaser. Master title, you don't need a state authority consent. It will be applied by the developer. So this obligation comes from the developer to apply for state consent blanket. So what does it mean, blanket consent? Blanket means it's still state authority consent. It's just a blanket, the whole place, the whole condo, for example, the whole project. So they will come up with a list, and that list will include the person who is the last person in the record of the developers, because sometimes some owner has changed hand, even though you have been buying the house like in 2000, it could have been sold in 2015, for example. So developer has to make sure they have the right owner to apply for the blanket consent. I've mentioned already, even if the transfer of property to family members without consideration, or anyone without consideration, you will still need to apply for state authority consent if there is the sekatan kepentingan. Okay, and as I mentioned, land rules, they differ from state to state. They have different kind of application fees. They have different forms. Please make sure that you are signing the right form, because if you do not sign the right form, then you may have to come over to sign the right form, the other form again with your lawyer. Like I mentioned earlier, consent, if it's not approved, or rather it's being rejected, you can appeal. You can appeal. But this will also mean that you will fork out costs and time. Unlike a standard agreement of 3+1, the state authority consent or any kind of consent will take more time than the 3+1 to complete. Yeah? This means that you cannot charge as a seller, you cannot be charging interest until the 3 months has commenced and ended. All right. So you cannot be starting at the time of the agreement. I repeat that because sometimes we tend to not understand that state authority consent is something not of the purchaser's control when it comes out, or not of the vendor's control when it comes out. So you cannot dictate the 3 months to start from the day of the agreement. Now, let's go for foreigner consent, shall we? So as I mentioned, foreigner consent is under 433B of the National Land Code, and it is a prior approval that must be obtained from the state authority in order to do any dealings of transaction of acquisition, meaning that you can transfer it to a foreigner, you need to apply for foreigners' consent. Foreigner interest here is individuals who are not Malaysian citizens, okay, not Malaysian citizens, and this includes those with residential PR, permanent resident, yeah. Companies can be foreigner companies as well. So foreigner companies are companies that have more than 50% acquisition in the company as a foreign entity. So there it goes. Local companies can also be foreigner company because they have a non-citizen or non-Malaysian that has more than 50% of voting shares. Foreigner consent, actually I want to show you how it looks like. I mean, not the foreigner consent, but the National Land Code. Okay, so National Land Code here. So you see the 433B? So it says here, non-citizens and foreign companies may acquire, etc. land only with the approval of state authority. This is the foreigner consent. So even if you do not see it in the title itself, it's in the National Land Code. This is actually transaction of transfer, but only after the prior approval. So that's why I mentioned that foreigner consent is not something that you can see in the title, but it's in the National Land Code. Whose duty is it to apply for foreigner consent? For this, it's not the vendor, it's the purchaser, because they are the foreigners. So if the foreigner is a vendor, do I need to apply consent? For foreigner consent for the vendor? No, you don't need. But if your title has state authority consent, yes, you have to still apply. Foreigner or Malaysian, you have to apply. But if you are foreigner selling, you don't need to apply for foreigner consent. But you buying, yes, you apply for foreigner consent. And here also different state has different requirements. And some states actually impose levy. Levy is additional tax paying for the foreigner consent once it's already approved. So for example, in Penang, they charge 3% from whatever the amount of the purchase price or the acquisition price. So in order to get the consent. So consent approved, you have to pay this levy. Okay, Malacca 2% and Johor is 2%. So far, Selangor and KL do not have levies. All right. This is the threshold for minimum payment. Those who wants to take a screenshot now, I'll wait for 5 seconds. Yeah. So anyways, this is the states that we have gathered. In KL, your minimum threshold is 1 million. In Selangor, there's a bit of a little bit more of types of property. You can only buy, this is for foreigner, you can only buy strata title properties. Landed is not allowed. Landed strata can, because some properties now have landed strata. Cannot purchase auction property or agriculture lands, all right? And you must not split into zones. So you can only buy, like, for example, it's in Gombak, it must be a Gombak area, not Gombak and Kuala Selangor or whatever lah. It's not in between zones. So zone 1, 2 million threshold. The zone 1 is Petaling, Gombak, Ulu Klang, Sepang and Klang. So these are actually prime area land or property, yeah? So prime area property, 2 million and above. Zone 2, Kuala Selangor and Kuala Langat, 1.5 million and above. Zone 3, Hulu Selangor and Sabak Bernam, that's 1 million and above, okay? These are the threshold in Selangor. Johor, as you can see, 2 million, and it must be landed property that is designated for international zone. So you know Johor has a lot of different zones, yeah. And then it must be the high-rise or strata title within the non-international zone is 1 million. So international zone is 2 million, non-international zone is 1 million. Kedah, all districts except Langkawi is 600,000 and above, and Langkawi is 1 million and above. There's no restriction that we know of that whether they can buy strata or blended. Same as KL, there's no restriction. Only Selangor, only strata. Malacca, landed property was be 1 million and above, strata title 500,000 and above. Kelantan 1 million and above, no sound of restriction of any types of property. Negeri Sembilan and Pahang 1 million and above. Penang, the island itself is 2 million and above, and mainland is 1 million. Okay, so Perlis, Perak, Sabah, Sarawak, you can have a look itself. So this is the foreigner consent threshold to purchase property. So if you do not buy within this amount, your consent for foreigner will be rejected. Okay, now we go for low cost consent. Low cost consent or low cost property, those are meant for those with lower income, hence why they do this low cost property consent. It is it's applicable to properties in Selangor, and you have to apply at Lembaga Perumahan dan Hartanah Selangor, LPHS. Let me just share with you how the website, because now you can apply via the website. So if you see here, this is the LPHS, yeah, and this is for low cost. So there's in here you can actually find what are the requirements for low cost consent. Means not everybody can apply, and the application will be allowed. You know, there'll be a rejection. And why is it rejection? Because you might not fit the bill, they say. So I've done one low cost recently, and the applicant must be a person who's never had a property before. Their salary is in a certain bracket, and etc. etc. And also for the seller, in order for them to sell, you must also fit this bill as well, which means the property must be acquired more than 3 years in order for selling. I think 3 years, if I'm not mistaken. But the whole syarat here, let's just open the syarat here. But the syarat here, pemilik hartanah mestilah mencukupi 5 years. Means you must have that property 5 years before you can sell. Okay, and then for the buyer must be 18 years and above. You know, what is the amount of the property? Okay, if got husband and wife. So all these things is the criteria for a person to purchase. Just the same as when you're a foreigner. So criteria to purchase a low cost is like that. It's not endorsed on the title. You have to look it from the previous sale and purchase agreement and land search. Sometimes land search mentions that it's a low cost property. I've already mentioned this is requirements. Yeah. Now, Bumiputra consent is also not something that's endorsed. It doesn't mention Bumiputra on the title. Yeah. It's something that is allocated by the developer when they submit to the land office. So they have to, when the developer builds a property, they are also subjected to certain requirements by the government or the land office. Yeah, when they submit, they have to submit how many units according to the percentage and things like that. That is Bumiputra lots. So Bumiputra lots means here you cannot sell to a non-Bumi. Okay, it's not allowed. However, under certain circumstances, if the Bumiputra lots can be switched, or rather one Bumiputra lot is switched by the developer with another Bumiputra lot, then it is possible to make that Bumiputra lot Bumi to non-Bumi, non-Bumi to Bumi. So it is possible that the Bumiputra lot becomes non-Bumi. Then only can sell the property. Of course, this is an internal thing, and usually this is at the discretion of the developer as well. So if it does mention, it will say here. If it does mention in the title, it will say something like this. Tanah ini tidak boleh dipindah milik atau dipajak dengan kebenaran bertulis oleh pihak berkuasa negeri. Sekatan ini dikecualikan kepada pembeli Bumiputra bagi pindah milik kedua dan seterusnya. You cannot transfer, but it can be transferred if you are a Bumiputra. Last topic, top points. Process and timeline. And this is going to be really fast, guys, because actually we are working on a timeline of the land office. Okay. With that, I'm sharing with you what I know. The process and timeline of an application. So there will be an application form, and in the form, there's a lot of documentation that needs to be compiled. So usually it will take about roughly a month or so, or lesser, if during the SMP drafting, everyone knows what needs to be done, you probably will get the documents faster. You know, to get the documents faster, when time to sign the SMP, you sign the SMP, you sign the forms, and then you get everything notarized or affirmed by the commissioner for oath, and you get the letter ready and you submit to the relevant land office. Upon submission to the land office, how long does it take? That's always the burning question. Everybody will ask, how long usually, Sarah, it will take for the land office to approve? So here's my answer. It's not a fixed period. Usually what happens when you apply for a state authority consent, your application comes in along with everybody else's application. It's stuck in a desk or an application table, I don't know. So it's there in the land office, yeah? So every month, the state authority, it's not a matter of people just chop consent apply, consent approve, chop, no. It's actually brought in. The whole files, the whole pile is brought in for a state authority meeting. So the land office will actually review one by one whether to approve or to reject. That's why it's not the land office, the officer you see when you go to land office. No, it's not that. It's the officer above, as in the ones that are the director, the director of the land office. They will see each and every file. So the timeline is not fixed. Sometimes we get KL land office to approve within a month. Sometimes we get Selangor land office, there's a 3 months. Sepang, there was one time it was 2 weeks. It really depends. There's no timeline. And I'm having, just to share with you, I'm having difficulty with foreigner consent in Pahang. So ladies and gentlemen, please do not buy a property in Pahang if you're a foreigner, because they are, and I'm kidding you not, they are still trying to approve a 2017 foreigner consent list. So my client is stuck no matter what I do. No, it's 2022, yeah? So we're trying our very best. So in other words, you have to be familiarized with the land office first in order to apply the consent. But the timeline, usually if you put in the agreement, because I know in the agreement sometimes you need to put timeline, right? So you put in, to be safe, 3 to 6 months, but depends. KL 3 to 6 months. I would say Selangor 6 to 9 months. Other states, we have to check with the land office how frequent their consent application is approved. So with that, ladies and gentlemen, with all my shares, I really hope I have shed some light and we will start answering some question and answer.
Thank you, Sarah. Okay, we will now take questions from the participants from the Q&A box. Okay, first question. Is there another layer of approval required for land transactions for an amount more than 20 million ringgit that needs to get EPU approval to ensure that there's no dilution of Bumi interest? Can you elaborate on the reason and thought process behind this additional layer of approval?
Thank you, Diana. Well, EPU approvals, usually it's foreigner investment. Last time it's called FIC, but no longer FIC. Now EPU is more towards that. But I agree, there are, for those transactions, more than 20 million. Same as any other state authority consent, the main reason of it is to ensure that there is no change of hand that is not within the government's, they have to look into these matters, because land for them, they want to make sure that land is not easily changed to some entity that they are not aware of. So usually this EPU approval also works for that, because economic reasons usually the reason why they have this additional layer of approval. So I hope that answers the question.
Okay, next question. We have a number of questions here. Next question is there, Okay, for freehold properties with no restriction in interest, does that mean that there is no actual way for the state to track if the Bumiputra is met for a certain property development?
Thank you, Diana. So freehold properties with no restriction in interest, this does mean that the owner can freely sell the property, because that way, once you've already, you purchase the property from the developer, because I saw the development part. You purchase the property from the developer and seeing that most probably you already have the title with you and you are the proprietor. So you can sell at anybody, as long as, in the title, it doesn't say you have to apply for state authority consent. When you do have a state authority consent, that's where there's a possibility that Bumiputra thing arises, like I mentioned just now. So if there's a state authority consent, the government will have a look who is buying your property. So if the buyer is a non-Bumi, then when you sell your Bumi, like for me, I'm a Bumi, I'm selling to Diana, for example, then my application will be rejected firsthand. Why? Because I am selling to a non-Bumi. So it doesn't state in the title, yeah, so non-Bumi or Bumi, whatever, but it states that there's a restriction in interest. So if there is no restriction in interest, that property or that development, that person who's buying or selling does not have an issue with Bumi or non-Bumi.
Does the low cost and Bumiputra consent apply to subsale units as well?
Yes, the answer is yes, it does apply. When you subsale, let's say I bought it at a low-cost house. Let's just say I bought a low-cost house and I'm selling it, subsale selling it to another person. So the other person, in my SMP, it says low-cost house. So the other person have to apply for consent, and I have to make sure I follow that, whatever the requirements is in LPHS. So yes, low cost and Bumi, the same. You have to apply for consent once you subsale it.
Freehold lands in Cyberjaya also couldn't get consent to transfer from Malay to non-Malay. Why is that so?
Freehold lands in Cyberjaya cannot get consent. Malay to non-Malay, okay. I have to see the title first, because sometimes you have to look at the title. What does the title say? If it says Malay Reserve, then yes, Malay to non-Malay, no issue, cannot transfer. Why is that so? It's the government's planning. This is all government's planning of land, so you can't change it unless you can. There's some places that they have done Malay to non-Malay, but you have to substitute it with another land. So if you coincidentally have another land that's non-Malay, you want to substitute with the Malay, then can. But that's very unlikely lah.
Next question, may I know how to determine whether the property is subjected to foreigner or low cost and or Bumiputra consent?
Like I mentioned previously, foreigner is under 433B. It's not in the title. So if you are a foreigner, you have to apply for consent. Low cost is on your sale and purchase agreement, and Bumiputra lot, usually it's when you want to subsale it during master title. So if it's already with individual title, you will have to look into whether you have sekatan kepentingan. That's where the Bumiputra lot might just arise.
What about foreigner purchasing individual title, (industrial) within Selangor? Would this be rejected outright or rejected but subject to appeal? Foreigner is wanting to set up a business locally.
You can, it doesn't have industrial sekatan yet, no restriction for industrial, but you have to buy a property that's strata. I think there's a guideline for industrial. For industrial, you need to set up business. Yes, you need to set up a business. You can't buy the property individually. Means the foreigner must be a company. The foreigner must be a company to purchase that side of industrial property. But this is also subject to other restrictions like the threshold, how much is the property, and those things. That it comes together hand in hand. So if there is a foreigner that's buying, they have to set up a company first, then they can able to buy a commercial or industrial land, or not land, basically the property.
Next question comes from Suk Lim. She asks, since it is not indicated in the title bracket Bumi lot, how do we ascertain it is Bumi or non-Bumi lot for purchasers checking?
You have to check who is the owner usually. If the owner is non-Bumi, then no issue. Okay, if the owner is a Bumi, then you have to check that the sekatan kepentingan or not. That's where the issue lies. Okay, so I repeat, if there is a sekatan kepentingan and the owner is a Bumi, there is a possibility it will be rejected. But you have to appeal lah. So that's what it means by Bumi lot or non-Bumi. Another one is this Bumi lot always arise when you're buying the developer property. It's not usually on the sub-sale. Means that when you buy a developer property, the lot is already allocated as a Bumi lot, but it has not been subdivided into individual title or strata title yet. So once it's already individual title, strata title, who is the owner? So if the owner is a Bumi person, then you have to sell to a Bumi lah. Usually that's the case. But if it's freehold, it's not freehold. If there is no sekatan, then it's fine.
What a Bumi lot is successfully released to a non-Bumi purchaser, and the non-Bumi purchaser then sells it to a Bumi purchaser. Does it revert back to Bumi lot status?
Bumi lot becomes non-Bumi, and non-Bumi sell it to Bumi. Sometimes it does. It really depends on the status of the sekatan kepentingan, because we will, when you apply, if there is a sekatan kepentingan and you apply for the title to get consent from the state authority, that's where it will trigger who is the owner right now. But some land, that's why some land and some other state, they have the Bumi, non-Bumi. They have this thing says that if the owner is a Bumi, and then so it's actually on the title, so Bumi and then sell to a non-Bumi, then you don't need to apply consent after that. So that kind of thing. That you have to look into the title. But if you don't see anything on the title, you don't see sekatan, then it's possibly not a Bumi lot. This is the only issue with us conveyance as well. So I don't know who's the anonymous attendee that's asking these questions, but this is also an issue for lawyers as well, because we can't really give you a status report whether it's a Bumi or non-Bumi until and unless we get to deal with the land office.
Judy asks, if after appeal, state consent is still rejected, what can be done by the purchaser?
This one, usually you are given twice appeal. If the second time you appeal still reject, then you really can't sell the property. So you either negotiate to another person to buy, or change person, I don't know, but you can't sell it to that person. The state authority not allowing it. So that's why. Although the vendor is applying it, the vendor will look at who are you selling it to. So possibly you have to change purchaser lah. And that means if you're selling it to someone else, you have to terminate this one lah. And then you have to give back all the 10% back. Yeah, but no penalty lah, because it's not your issue, not your fault.
New project developer do release unsold Bumi reserve units to non-Bumi sales. Kindly elaborate level of applications involved.
So new project developer do release unsold Bumi reserve units to non-Bumi sales. So as I mentioned before, there is possibility of doing that by doing a transfer. So sometimes they transfer the properties from a Bumi to non-Bumi, non-Bumi to Bumi. So they meaning the developer, only they would know what is their capacity, or what is their amount of Bumi and non-Bumi. So I hope that elaborates the level of application, because application is mostly on developer side, not on the lawyers, legal, or the land office on that matter.
Is there a situation where foreigner has applied for foreigner's consent, when buying property from developer, consent letter from KL Land Office has gotten. And when the strata title is issued, now during perfection of memorandum of transfer, the foreigner will need to apply for consent again.
No, unless the foreigner go and sell to another foreigner, then you apply consent. But if the name is still the same, you apply that consent, it will be on the same KL Land Office consent letter. But I understand where you're coming from. Some consent letters have that 2 years period and whatnot. So you just need to make sure it's renewed, or you just inform that KL Land Office that this was applied when it was under master title.
So Lincoln asks, there is a low-cost property under liquidator and the developer went bankrupt. The S&P is in 2003, currently awaiting CF in 2022. How do I obtain confirmation that Selangor State Government needs to consent to the ownership transfer from liquidator or contractor?
For your info, that means the developer is no longer in the picture. You would need to apply to get it from liquidator lah, not contractor. You punya application to LPHS will have to be done by the liquidator, not the contractor, because the developer is bankrupt, right? So we have to get it from there. The liquidator, in other words.
Selling low-cost house needs consent. How about the price, resale price? Any ceiling or restrictions?
Yes. For more information on that, Nick, I would suggest you go to the LPHS website, because what I showed you just now will mention the price, the resale price, and other restrictions of selling a low-cost property.
Next question. It seems as though the land office is imposing more variations of sekatans and making it much more difficult for smooth transaction. Have you noticed this trend as well?
Well, Anonymous, actually, to be honest, it's the same. It's still the same. It has always been the same. The sekatan has been there, and the ones that change is not the land office, is possibly the sekatan, the restriction or the whatever the requirements are the same. It never change. But the ones that are reviewing it, that's the person that's not the same person. It could be changed in 5 years, 3 years. They're not the same people. So I don't notice. So far I've not noticed. Yeah, consent that's been rejected outright. It's just application. Just apply like normal and see how the result is. That's all.
Do all restrictions in interest will be indicated in the title?
Yes. That means whatever the restriction in interest, it will say that sekatan kepentingan, it will say tanah ini tidak boleh dipindah milik dipajak digadai. Means you cannot transfer, charge, mortgage without the state authority consent. So it will say that. If there is none, they will also say tiada, none.
Is there a timeline to apply for strata title? If yes, is there a difference whether the title has restriction of interest or not?
Timeline to apply for strata title, Judy, I think your question is about developer application for strata, right? So the timeline is really depending on the developer. They will apply nowadays. Okay, there's a period where the Strata Title Act was not yet there. So when it was not yet there, there's developers that from that time on behind, they might still be under master title because their timeline has not been certain. But now that there's a Strata Title Act, everything goes from here on out. That one, they have timeline. So they have timeline to apply, to issue, put in whatever their documentations and whatnot. So the restriction in interest is just an additional, they have to apply for blanket consent. That's just additional. So strata title comes out, the developer can submit for the restriction in interest, the blanket consent later as well. It's not necessarily you apply for strata title means the developer applies for strata title at the same time apply for the restriction interest, the blanket consent. It doesn't have to be that way. So it doesn't really make any difference of time in that sense. If you're talking about this, when I read this, is there a timeline to apply for strata title? I'm assuming it's the developer because us as individuals or persons, the proprietor itself, you can't apply for strata title. The developers have to, so they have their own timeline and procedure. So does not make any difference. It's just a matter of, like I said, old properties, they can be in master title forever until until the developer decide, okay, I'm going to apply for strata title now.
Can we have the minimum requirement purchase price for foreign purchase again?
So these are so far right now, this is the minimum requirement. Yeah, minimum requirement of the state authorities, Selangor, KL, Johor, and Kedah. Then this is Kelantan, Melaka, Negeri Sembilan, Pahang, Penang, Perlis, Perak, Sabah, and Sarawak. This is minimum requirement of purchase for foreigner, not including any administrative or cost when you apply for consent or levy. Semua tu is different.
Thank you, Sarah. Thank you for sharing your insights. It has been a very insightful presentation. Do follow or like our social media accounts. And fourthly, if you would like to speak with our lawyers, we offer a 30-minute complimentary consultation over the telephone or over video conference. Please fill in the form on our website, and the link is posted in the chat box. Thank you for joining us. We hope you have found today's session informative and useful. We will see you in our next talk.